Welcome to Your Money, where the goal is to equip you with practical information that can help secure your financial future. This month, we'll be talking about the importance of an estate plan. Most of us go to work every day to earn a living to support ourselves and our family. We do this because we love them. We do this because we want to provide for them. And in the event something should happen, resulting in us becoming incapacitated or even worse, we're no longer here, we want to be ensured that what we leave behind to support our loved ones is being distributed the way we want, to who we want, and when we want them to have it. Should we ever become unable to make our own medical decisions, we want to determine upfront who can decide for us other than the state. The reality is, without a properly drafted estate plan, your financial and medical decisions could become irrelevant, and the very people we love and want to provide for could be subject to the rules of the state, which may be very different from what you may have wanted. Our guest today is attorney William Hayes. Attorney Hayes speaks throughout the Los Angeles County on the topics of estate planning, business planning, and asset protection on behalf of many civic and community organizations. He is the author of Contracts, Business Entities, and Trusts section of the book Wealth is Possible. He is a member of the exclusive American Academy of Estate Planning Attorneys. Attorney Hayes earned his Juris Doctorate degree from UCLA Law School, where he was a member of the prestigious Law Review. While in law school, he gained national recognition for a private interview that he conducted with the late United States Supreme Court Justice Thurgood Marshall. But despite all these accolades, Attorney Hayes' primary focus is to help clients avoid probate, protect their assets, and provide for the security of their loved ones with a well-crafted estate plan. And that's why we're here today. Attorney Hayes, thank you for appearing on our program. Before getting to my questions, I must ask, what was that experience like interviewing Supreme Court Justice Thurgood Marshall?
Oh, it was a wonderful experience. He was an extremely down-to-earth man. We had a great time talking. We spent several hours in his private chambers. He was a salty old guy. He liked to tell dirty jokes, great sense of humor. It gave me a lot of insight into his experience that brought him to the point that he became a Supreme Court justice. I mean, this guy had a real storied history with regard to civil rights and his personal involvement on the front line. It was just a really wonderful experience to have met a piece of history.
To help us get somewhat of a grasp of estate planning, could you explain what is an estate plan and why would a person even need one?
Well, if you don't have your estate plan, you're subjecting yourselves to the process of probate. Probate is a government-mandated plan for the distribution of assets of people who have died. Probate also incorporates the handling of the affairs of people who are disabled, usually adults. If you don't have an estate plan in place, you have to go by what the state has in store for you. But if you want some control over your life, if you want some control over how your assets are handled and how your loved ones will receive those assets without delay, without public exposure, which probate requires, and without the cost, which is significant, because that's where most attorneys make most of their money in estate planning. If you don't want to avoid all of that, you better do some planning.
I've seen offerings advertised to prepare estate plans by those who aren't attorneys. Why is an estate planning attorney the best one to set it up?
Well, I've seen those ads too. I mean, you can always go out and buy a form if that's something that you feel is adequate for you. However, what I have found after having done this for over 30 years is that it's generally not adequate for most families. What those types of forms do is just distribute the monies. They do nothing to incorporate the problems of each family. So for instance, most people, 7 out of 10 people over the age of 65 will wind up with long-term care issues in their lives. Those forms do nothing to address those issues. Those forms do nothing to address issues such as remarriage. What happens upon the death of a spouse and that person remarries, and how will that affect the assets of your spouse and your children? That's something that is not covered in those plans. The specifics of how you leave assets to family members or friends is not addressed in those types of forms. For instance, you may have one person who's irresponsible and you want to leave the monies in a certain kind of way to protect that person for that person's benefit. Or you may have another person who has special needs and you want to make sure that person is protected, because if you leave monies to a disabled person, the state will insist that they spend all of that money for their care before they will give any more money. Or you may have a person, a child or a friend who's married to somebody that you don't feel comfortable with. You don't want to leave the money to that person and they then commingle the money with that person and they wind up in a divorce and then your money walks out the door. There are all kinds of reasons like that. Those are just examples. You want to get somebody who's experienced. I have to do 36 hours of continuing legal education in estate planning alone as a member of the American Academy of Estate Planning Attorneys. 36 hours. Now, the average attorney in California has to do about 8.3 hours a year. And that can be in divorce, criminal law, civil law, etc. 8.3 hours. We have to do 36 hours every year in just estate planning alone. That gives you some idea as to how complex this field can be.
Yeah.